Your Lordship. Lordship, I beg to make a mention of listing one matter at the end of the board. Some urgency is there, Your Lordship. I'm praying for interim protection.
Okay. End of the board.
Your Lordship.
Everything is ready.
Yes, Your Lordship. We have filed yesterday. Your Lordship.
Yes. Who's appearing for petitioner?
Please, Your Lordship, I'm appearing for the petitioner.
You're for the petitioner?
Yes, Your Lordship, I'm appearing for the petition. This is a contempt petition, Your Lordship.
No, you're wrong. This has nothing to do with contempt.
I think my learned friend is mentioning daily list item number 1. This is
Yes, Your Lordship. My apologies.
I think there's always that confusion, no? Supplementary list, main list, all those things. Yes, tell me who's appearing.
I'm there, Your Lordship, for
May I
speaking.
please, Your Lordship? Lordship, this is an application under Section 5 of Limitation Act. Lordship, for condoning the delay of 39 days in filing the criminal appeal against the judgment passed by the session judge, West Giant Hills.
Where is the application for condonation? This is the order. Delay has not been condoned.
No, Your Lordship. Your Lordship, initially we filed this criminal appeal under Section 415 of 2 of the NSS, but Your Lordship, we have made necessary corrections, Your Lordship.
Oh, I think this.
May it please Your Lordship.
This is the matter
Lordship, Lordship, kindly have the memo of appeal.
Yes.
This is a pre-July conviction, Your Lordship, and an appeal has been filed under the new code, that is the BNSS, Your Lordship. Now the question, because I have raised the objection, because since it's a pre-July conviction, Your Lordship, in my humble and respectful submission, Your Lordship, appeal would not have been filed, Your Lordship, under the new code, Your Lordship.
Yes, I think now I
Lordship, yes. Lordship,
what we have to do is, before we proceed with this matter,
Lordship.
We have to first determine
Lordship,
as
yes.
to which code will apply.
Lordship, yes. Lordship is absolutely
So
correct.
we'll hear the parties on that
that
limited
point, Your
aspect,
Lordship, yes. Lordship.
then we'll proceed.
Lordship.
Yes, Miss. So please start.
Your Lordship, I pray for 1 week time, Your Lordship.
Or you
To
can
be
come
ready with
tomorrow,
the-
Your Lordship, because what happened, Your Lordship, there are conflicting, number of conflicting judgment, Your Lordship. Say like from Punjab and Haryana High Court, Your Lordship, say yes, it should be filed under the new code. Kerala High Court followed the judgment of the Punjab and Haryana High Court, but Rajasthan High Court say no. Even before the Delhi High Court also, they are conflicting, even in the Delhi High Court, Your Lordship. But today, I'm sorry, Your Lordship, I have forgotten to bring those judgment, Your Lordship. I could have placed before, Your Lordship. If Lordship I can come tomorrow, then I'll place all those judgment, Your
Tomorrow
Lordship.
will not be here. I mean, I'll not be here.
Then, Lordship, if on 13, Your
We'll
Lordship,
have it on 13.
13, Lordship, I'll place.
Yes, Miss. You do one thing. You also study the matter. Try to find out the decision of High Court or Supreme Court in as far as this issue is concerned, which will be applicable, the new code or the old code. And
there's certain matters before to learn single judge also, which are connected with this issue. Whereas I would pray if Your Lordship also tag those matters in, because any orders that fall from Your Lordship sitting in division bench or that would have a bearing in all those other matters as well.
but they will follow suit. Whatever order is passed by the division bench will be applicable.
If that bills, then we will not have the occasion to address Your Lordships on this issue. Because since it's a criminal appeal minutes, it would affect my rights. Because a similar objection is there in the other matter as well. So we'd not be in a position to address Your Lordships in this appeal.
Okay, that will.
Lordship may be pleased to.
Yes,
Lordship may be pleased to invite the
Yes, I think-
council to address the
yes,
issue, Your
we
Lordship.
can do that. We can do that.
Lordship,
Not
yes.
necessary. Not necessary. No, because if we call for, then it will be an administrative chaos. Whatever the
Lordship,
case may be.
My lords, my only prayer is the lordship may
You
kindly
can,
just hear
yes,
us.
members. Yeah,
Consult the bar,
as
consult
my
the bar.
brother
So
said,
definitely we'll have no.
any member of the bar can be. This is a new area.
Lordship.
Hey, it's a new area we are venturing. So I think opinion of all would be welcome. So we'll take up the matter
On 13, Your Lordship.
13.
13. Apply, Your Lordship.
pray made by the Land Council for the applicant. This is matter on 13th.
Apply, Your Lordship.
It is however made clear that the preliminary issue.
Sorry, Your Lordship.
It is however made clear that the preliminary issue to be decided in this matter is with regard to the applicability of the old code, that is the Code of Civil Criminal Procedure 1973, vis-a-vis the new code
BNSS, Your
the
Lordship.
BNSS.
2023.
2023.
Lordship. Apply, Your
Please
Lordship.
accordingly.
On daily list, item number 1.
I am appearing on behalf of the petitioner here. Lords, in this matter, I may make a request. Lords, we are being
Petitioner?
led by the advocate.
My learned friends for the petitioner.
Lords, I may make a request. Lords, we are being led by the Advocate General in this matter. He is not available, Lords, today. So I'm requesting if the matter could be taken up, Lords, on any short date next week, Lords, subject to convenience of the court.
13th then.
Next week. 13.
Okay. Obliged, Lords.
On pray made by the party on accommodation sought for by on behalf of the Learned Advocate General who is indisposed. The same not be objected to by the respondent. Matter is adjourned. List the same on 13th.
13. Obliged. Obliged.
Obliged, Lords.
Oh, that much. Why has not come? Suka lawyer. Secret. I don't think we'll be able to wait for. What we can do is. Let the matter come up tomorrow.
Tomorrow, Your Lordship.
We'll not pass any order because since the file is not. You make a mention tomorrow.
Your Lordship.
You make a you see, you make a
Your Lordship, some
you make a
urgency is
request
there.
before the you make a request before the registry, indicating the urgency of the matter, and an order will be passed.
Your
Administrative order or otherwise will be passed. Available bench will sit tomorrow.
Your Lordship.
Please, Your Lordship. Lordship, I beg to make a mention for item number 4. Your Lordship, I pray for 2 weeks' time, Your Lordship.
This is the land acquisition matter
Yes, Your Lordship.
on pre-made by the appellant seeking accommodation. Matter is adjourned. This is the same after 3 weeks.
Obliged, Your Lordship. Good day.
May it please, Lordship. Lordship, I beg to make a mention of item number 6, Lordship.
This matter has not been heard
It's not been heard, Your Lordship.
on pre-made by you are for
Petitioner, Your Lordship.
For respondent number 6, Lordship.
any objection
No, Lordship.
on pre-made by the petitioner. Matter is adjourned. This is the same after 2 weeks.
Much obliged, Lordship. Your Lordship, I beg to mention item number 1. Your Lordship, I humbly pray to take up this matter after 2 weeks as the conducting counsel is having personal difficulties, Your Lordship.
No, I have no objections.
On pre-made by the appellant seeking adjournment. Matter is adjourned. List the same after 3 weeks.
Obliged, Your Lordship.
Supplementary list, item number 1.
Argument today, Your Lordship. I'm filing mine.
Yes, Mr. Day, have you
My lord, yes, it's ready, my lord. I will just, in the course of the day, I will hand it over, my lord.
the written argument
Yes, yes, my lord. It's already ready. I'm just printing out the.
and the records?
Yeah, record is also there. I will hand it over, my lord.
You are for respondent 1 and 2.
Yes.
What about respondent 4?
Respondent number 4, my lord.
Mr. Deb,
Yes, yes. He's in the legs, my lord. I will inform him to file it, my lord.
whether his argument is prepared or not, ready or not?
I have no idea, but he's there in his leg, my lord, on the other court. I was informed. But my one, my lord, I am filing it today, my lord, positively.
Mr. Day, the records that is produced
My lord.
contains all the relevant records.
Yes, yes, my lord. The entire file they have sent me.
Because why? You see, I would like to remark there are some matters, not in this matter, some other cases involving Nokma matters or matters from CEM, EM, where you did not give me the complete record. You have given only the record of the proceedings before the CEM,
My lord.
not before EM. That
But
matter
normally what happened, my
that
lord?
matter involves even the village code. Those records are also not there. Very difficult for the court to really understand.
Because my lord, what happened in that matter, my lord, because the CM order, it amalgamated the EM's order. Probably the record was not sent.
What happened is, you see, there was some issue as regard the non-joinder of necessary parties.
Oh yes, yes, my lord.
There
I
was
remember that case.
Nothing on record. as to-
Gondagiri, if I'm not mistaken, it's
yeah.
Gondagiri. I will find it out whether there is some more record.
I don't know who are the parties who have been impleaded before the EM.
I don't know.
Because what happened is usually in fact the array of parties should be listed properly.
Yes, yes.
Otherwise, you say so and so and others.
Well,
Who are those others? We don't know. You will know, but I'll not know.
I
Anyway,
will, even in that case, my lord, I will just find it out. If the EM order is still there, my lord, I will ask them to send
not
it.
the EM order is there. I'm not talking about the impugn order. Impugn order is there.
No, EM's order. EM's order.
EM's order is there.
Uh-huh.
It is there in the file, except for the actually what is required is the application that is filed before the EM, where the petitioner would list the name of the respondent.
Uh-huh.
Because I think the NOCMA was not
Made a
they were
party.
not made parties, so that was the anyway. That's beside the point.
My lord,
Just
I will
to
find it
find
out. But I will give the record. I will check once more, my lord. So, my lord, what I will do, my lord, I will just check once more whether EM and CM record are there or not, and I will give it tomorrow, my lord, positive.
But Mr. Depp is not here.
But record, my lord, I will give it tomorrow. But the written argument, I will give it today itself, my lord.
I may not be here tomorrow. We'll list it on Monday then.
Monday, my lord.
I think I'll be back on Monday only.
Lordship, if it's Monday, your lordship.
Only for the filing of the record.
Yes.
And the argument of the respondent number 4. As far as you are concerned,
Okay, your lordship. If that's the case, then
it's done. Mr. E.B. Sangwa, Learned Counsel for the petitioner, has submitted that the written argument on behalf of the petitioner has been filed today. Similarly, Mr. S.D. Learned Standing Counsel, GHDC, has also submitted that the written argument is ready along with the relevant records of the department to be produced before this court. However, at this juncture, the Learned SC would submit that some time may be allowed for the records to be properly classified and to be produced for this court on the next date. None appears for respondent 4. None appears for respondent 4. As such, there is no record. As such, it is not known as to whether the written argument on behalf of this said respondent is ready or not. Be that as it may, this matter is adjourned for the day to allow the respondent GHDC and the respondent 4 to file their written argument. List the same on 12.
Item number 3.
My lord, I am filing my written argument. The brief case of the fact I have given, that is be treated as a written argument.
Have you also listed any authority that you would like to rely? Are you relying on any authority? Are you citing any cases?
No, only one case I have cited.
You have
Yes, given there.
Yes, Mr. Day, I think.
My lord, is ready. I am submitting it.
Record?
Right. Record is also there, my lord.
Properly.
CM record is there, my lord, with me. Only the EM's record is not there. So I can submit the CM's order today and just give me 2 more days, my lord. I will ask them to send through special messenger, my lord.
Mr. Nongri, you are ready? So we'll list this on 13th.
Let it come up on Monday, my lord, this also.
Mr. A. Chancharika, Learned Counsel for the petitioner, has filed the written argument. Similarly, Mr. P. Nongri, Learned Counsel for the respondent 4, has also filed the written argument on behalf of the said respondent. As far as the respondent number 1, 2, and 3 GHDC is concerned, the Mr. SD, Learned Standing Counsel, has submitted that some time may be allowed for the
classification of the record.
Written argument to be filed.
Written argument, I am filing it, my lord. Only for the record, my lord.
For the relevant records to be produced for this court. However, in the meantime, the written argument on behalf of such respondents is filed. Accordingly, on prayer made by parties, this is matter on 14. So next date is the day?
My lord,
Next day you file.
Positively, I will file.
Much.
Item number 5.
Yes. All the councils are ready?
Yes.
Parties here?
May please, Your Worship.
Please.
In this case, my lord, I have filed a writ petition regarding the matter of one pata in the Gentile Hill Autonomous District Council.
Please.
Basically, the petition is with regard to the illegal and wrongful issuing of landholding certificate, my lord.
Yes.
By the respondent, Gentile Hill Autonomous
Before my
District Council.
senior start, my lord, I want to raise the issue of maintainability of the petition. It is an appealable order, my lord.
No, I think, if I'm not mistaken, perhaps it is in this case that we have decided.
Yes, yes.
For the whole
Yes,
the issue,
yes.
The whole matter to be heard on merits as well as maintainability.
Yes. So
Yeah.
first,
If it is not maintainable, then matter ends there.
You will be addressed.
First, my learned senior.
You will be addressed both.
Yes,
you will be addressed. Everything will be
my
addressed.
learned senior has to address. What I am saying is this, my lord. Instead of going into the merit first, my lord, the merit will come second, my lord. Here is the maintainability. My lord has to say that it is maintainable.
That is for him to say whether he start with maintainability or he start with the merits.
So,
I'll start with merit because on the merit base everything, my lord. Because in this case is illegal issuing of pata, my lord. The area is 2418. The pata number 2418. The area is only in 4548. And they have mutated, my lord, in 5 different pata. Out of that, so that it is very much beyond the record, my lord. The pata is in pata, the pata 2418, my lord, which is in page 42, my lord, in page 42 of the petition, my lord. In page 42, my lord, of the annexure 7, my lord. This is a pata number 2418, my lord, and it's a name. The name of the place is Kli Lama Nang, and the area there is very clear, my lord. It is. I don't know the area name. The area is in 4548, my lord. There in page 42, my lord. And out of this 445, and this is a matter of
Who has
record.
issued this matter?
The respondent 1234, my lord, is the respondent, district council, my lord.
Settlement officer, my lord. 42.
42, my lord.
Annexure 7.
Where is it?
The signature there is very clear, my lord. Is by the chief executive member, my lord.
Oh.
The chief executive member is already a respondent number. And all the official is 141234, my lord.
So, Mr. Kanjing, correct me if I'm wrong, a pata is issued with regard to a certain landed property.
Yes.
Said to be possessed or belonging to somebody.
Yes.
So, as is the land tenure system in our part of the country.
Yes.
Land would belong to the individual.
Yes.
So,
but
in
that
this
is
case,
not the matter. I am not in dispute regarding that. Okay. Out of this, my lord, then it was made with 5. There is a sale deed among these respondent 4 and 5. And then out of that, they have made 5 pata. The landholding certificate of the 5 pata. And if your lordship calculate the whole area, it is beyond that area laid down by them. That is, which is quite illegal, my lord.
yes, and how are you? Who are you? You are the village.
My lord, yes, I am the village. It's a lengthy process, my lord. That's why I explain it step by step. There is a village Namdong E, my lord.
Yes. And
another also Thatmandri and Namdong, they are in cooperation and in enjoyment of this particular plot of land, my lord. There is no dispute regarding the thing, the area, the landholding certificate matter. There's no dispute. But the fact remains that it is issue beyond the record, my lord. The record is very clear, and they have issued it quite illegal, my lord. And we have object to that. And it's on record, the objection is there. So that's why we filed a writ petition, my lord. And the writ petition is very clear when the factual thing is clearly stated. It's clearly stated. And then it is on the face of it, everything is illegal. Red lie, my lord. This I have relied also in Supreme Court decision, my lord. In Supreme Court decision, my lord, as reported in EIR Supreme Court 1226 2013 EIR SCW 1174, my lord.
You have given the list of
yes, I've given, my lord.
Books. Para?
Para 16, my lord.
Para 16.
16. 16. I know the way you want to slip.
There's no para 16 here, only till 8.
I think
You're talking about this AIR 2003 SC 2120.
if you have already set up, I will give you a copy, my lord.
Please give me the citation again.
The citation, my lord, is the Supreme Court 1226 AIR 2013.
2013.
Then page 1226.
Sorry, we got the wrong book.
Para is 16 and 17.
Yes.
My lord, para 16 has clearly stated, thus a party seeking relief on the ground of discrimination must take appropriate pleading, lay down factual foundation, and must provide details of the comparable cases so that the court may reach a conclusion whether such authorities have actually discriminated against the party and whether there is in fact any justification for discrimination, assessing the fact of both set of cases together. The primary purpose of the writ is to protect and establish right and to impose a corresponding imperative duty existing in law. It is designated to promote justice and to grant or refusal is at the discretion of the court. This writ court cannot be granted unless it is established that there is an existing legal right of the applicant or an existing duty of the respondent. Thus, the writ does not lie to create or establish a legal right, but to enforce one that has stood already established. While dealing with a writ petition, the court must exercise discretion, take into consideration a wide variety of circumstances, inter alia, the fact of the case, the exigency that warrants such exercise of discretion, the consequence of grant or refusal of the writ, and the nature and extent of the injury which is likely to ensue by such grant or refusal. Hence, discretion must be exercised by the court on ground of public policy, public interest, and public good. The writ is equitable in nature, and there is issuance is governed by equitable consideration for issuance of the writ is whether or not substantial justice will be promoted. Furthermore, while granting such a writ, the court must make every effort to ensure from the averment of the writ petition whether proper pleading are being made. Further, in order to maintain the writ of mandamus, the first and foremost requirement is that the petition must not be frivolous and it is filed in good faith. Additionally, the applicant must make a demand which is clear, plain, and ambiguous. It must be made to an officer having the requisite authority to perform the act. Demand that further the authority against whom the mandamus is issued should to perform the act further the mandamus is issued should have rejected the demand earlier. Therefore, a demand and a subsequent refusal, either by words or by conduct, are necessary to satisfy the court that the opposite party is determined to ignore the demand of the applicant with respect to the enforcement of the legal right. However, the demand may not be necessary when the same is manifest from the fact of the case, that is, when it is an empty formality, or when it is obvious that a opposite party would not consider the demand, but so and so. So, my lord, I'll go through the fact of the case, then everything will be clear, my lord.
Yes.
Because the factual thing is that the area is that much, it is very clearly stated, and respondent 4 and 5 sell more than that. And the district council petition. petition, my lord, is very short. The humble petition is so. The respondent number 1 is the Gentile Hill Autonomous District Council. It's in the paragraph 2. And then respondent district council whose power and function are directly and exclusively under the supervision direction respondent number 1. Then, my lord, it is the paragraph 3, my lord. The respondent number 4 had been issued landholding certificate number 2022, landholding certificate 38 of 222, landholding certificate number 39, 37, 38, 39, my lord, 40, which is in utter violation of all the rules and regulation and procedure prevailing in the Ilaka and the Gentile Autonomous District Council. I've clearly stated, my lord, in paragraph 3. And regarding the petitioner, my lord, the petitioner begs to state that right Namdong has 12 villages in its jurisdiction, Namdong A and Namdong B. And then, my lord, this particular land also has been handed over to, in paragraph 10, my lord, I have stated that the Namdong village had handed over the said forest land, because this is a forest land, to the office of the respondent number 1, district council, for tree plantation.
So, you mean to say that the land in question is a forest land?
Yes, forest land.
Which belongs to which was handed over by the village?
By the village to the district council, my lord. And that agreement is there also. It is in page 37, my lord.
Yes, please continue. Where is the type copy?
Type copy is in the page 39, my lord. Agreement. For the preservation and conservation of the area, for the conservation and conservation of the trees and other species in the third Mandri, the government of the district council has decided to take over the area where the trees plant salt is growing. Other trees and boundaries are stated below. For the welfare of the village, the following statement.
Where is the indication of the area total? The measurement of the area.
The measurement of area. This is of the district council, my lord. This is the agreement made by them.
You have given the boundary agreement.
Yes, the boundaries is given there.
Must be a description of the total area.
North River Mungken, Kangra Road, Mungsing, forest land of district council. For the welfare of the village, the following statements are mentioned below. The forest as a whole is being taken care and looked and as per the laws of the land enacted by the district council, Gentile Autonomous District Council, July. As per the requirement of the village, if needed for the construction of school, churches, community, doorbar, and the bridge of the district council will supply wood or timber from the forest without any payment manner. If any of the forests are damaged, ruined, and destructed by the natural disaster, the district council will transfer or relocate as per the law. For the growth and development of the forestry, the district council is not allowed to bring in or employ immigrant workers, but if employment so and so. Then, my lord, the party involved. We, the headman of the village Namdong, I mean the petitioner, my lord, today, the 15th of July 1980, have put our signatories in the agreement to show that the village does not have any objection against the district council to take over the forest land. Now, or in the nearby future, and to look after the endangered rare tree within our district. Then was signed, my lord, by the Chief Forest Officer and the Secretary of the Chnong Namdong District Council, Jubai, and the Rangbat Chnong Namdong and the Chairman of Ram Namdong, my lord. And the same thing also, my lord, has been endorsed by the Annexure 7 by the Deloy, my lord. Because this fall under the Deloy of Nongjing, my lord. The English translation also is given, my lord, in page 41 regarding the office of Deloy, Nongjing Ilaka, Nongjing, so and so, my lord. So this is this 4548 is not included there, by my lord, but this area now, which the district council has given, fall under this area, my lord. That's why, my lord, is very much within the district council area, and then, whereas, my lord, there is an agreement among the village also that for the requirement they can do for the church, for the community bridge, and so on and so forth, my lord.
Yes, please continue.
So this land, my lord, has been given to the district council as per agreement 5th July 1980, my lord. And both the parties, my lord, have agreed to prohibit the extraction of kwas in all the areas, my lord.
Yes. Yes.
In paragraph 15 also, I have clearly stated, my lord, both the villages have agreed to prohibit extraction of kwas in all areas of the village from mixing so and so. The detail also is given. Then both parties have agreed to prohibit the cultivation of broomstick and all the areas of the village from mixing and so on. So that is already stated
paragraph?
in paragraph 15 of the petition, my lord.
Yes.
And as per the decision, my lord, both the villages have given permission to the resident of the respective village to cultivate other kind of cultivation in this area for the benefit of all, and that nobody can claim any right and title over the village land, neither in the person of the legal heir. Then, my lord, copy of the decision also is given there, my lord. In annexure 9, my lord, between the Thatmandri and the Namdong, my lord. Page 50, 50, ne? Kenapa ya? 52. It is on page 52, my lord, annexure 9, my lord. Then there is a disagreement also between the Namdong and Thatmandri, my lord. The joint village Durbar of the Namdong A and Thatmandri, which was held on 30th May 2019 in Namdong, in the presence of the resident of Namdong A and Thatmandri, and in the meeting was chaired by so and so Shri Arki Sumer, headman of Thatmandri, Shri Sir Langsing, and from the headman of Rai Namdong, Shri Elias Susngi, and in the meeting a joint decision was taken after obtaining consent from the resident, my lord. So the decision, my lord, is there, is stated there in page 52, my lord. Both the villages have agreed to prohibit the extraction, so and so. Both the villages have agreed to prohibit cultivation of broomstick, because that destroyed the forest, my lord, broomstick. Both the villages have agreed to cancel the landholding certificate and other document which was issued from the year 2003 onward, as the decision was already agreed upon by the two villages, Namdong A and Thatmanri, in the meeting held on 3rd April 2003. In connection with the boundaries of the paddy field, it was also agreed that only 10 meters, more or less, was permitted for every paddy field. And both the villages have given permission to the residents of their respective village to cultivate other kind of cultivation in this area for the benefit of all, and that nobody can claim any right and title over the village land, neither in person or other legal right. So as to confirm this decision, the leader of both villages have put a signature and sent herewith upon permission given by the village Jabar. Then this they have given, my lord, and they have signed by the Namdong and Thatmanri, my lord.
Yes.
Then my
So this, what you are referring to in page 52, would be the land that is in dispute now.
yes, because now
That is in possession or occupied by the respondents. That is your indication.
No, the thing is that, my lord, this now will come to, my lord, to the sale deed, my lord, because that sale deed is when he has only his land and he sold only the sale deed and dated 30th June 20, my lord, is in page 54, I think. 54.
You see, earlier you had referred to some forest land which was handed over to district council.
Yes, yes.
By the village.
Yes.
Then you come to another, I don't know whether this is the same land or another plot of land where the agreement between village, this Namdong and Thatmanri is there.
Yes.
So not the same land. Not the same forest land.
It is the same, my lord. It is the same. It's the same. But it's a big land, my lord. That's why. That's why the area also is.
That is why, you see, you should have first confirm the details of the area of the land, the boundary, bounded by, see, in land matters, it's very clear.
But the thing is that, my lord, in this petition, my lord, my grievances is that when they have sale deed is only as per sale deed of 30th June 20 is only 4548. 4548, correct? Oh, 30th June.
I understand what you're trying to say.
Yes, my lord.
That for a particular plot of land which is encompassed under an area of 4-5 something.
Yes, yes.
The land holding certificate was given to 5 individuals.
Yes.
And the total area
4548
of all those 5 would exceed that 4,000.
Whereas, my lord, when he sell this land in 30th day of June 2020, my lord, it is number 1, it is not registered, and number 2, no area provided. No area provided, and then he has made those land holding certificate, my lord.
Please continue, but I think this would verge on the area of disputed facts.
Yes, exactly.
Anyway, please continue.
There is no dispute. The dispute is that whatever happened is that the district council illegally issued those land holding certificates. That we have no dispute regarding that land. The dispute is that how can the district council issue land holding certificate? That is the point, my lord. Because the law say that when it is legally, when it is there, then how can you issue? How can things to be done which is beyond the legal aspect, my lord?
What is your role? What is your role as a village, as far as the power of the district council to issue land holding certificate is concerned? Are you to be consulted? Number 1. Is your permission required?
The role of the village, my lord, as far as landholding certificate is that it has to be from the Deloy of the Ilaka concerned, my lord. The Deloy of the Ilaka concerned. And in this case, my lord, that has not been done according to law, my lord. That has been done according to law. And we have also, it is on record also, my lord.
Is the Deloy an aggrieved person here? Has he approached this court?
No, we have not made him party, my lord. Huh? Huh? Yes, it's very much, my lord. Respondent 8, my lord, sorry. Respondent 8.
But I thought you are on the same side with the Deloy now.
No, my lord.
You've made him a
The
respondent.
Deloy of Nanjing is different. He's not, he's a different person, a different type of character.
No, this land.
That cannot be decided in writ petition.
Yes.
This land, see, let me be clear. This land falls within the Ilaka Nongjingi.
Yes.
So the Deloy is there.
Yes.
And your village also falls under this Ilaka.
Yes. But that's why, my lord, but the thing is that we come before the High Court because, for the writ petition, because it was not done according to law, my lord. That's the thing. When this land is very clear that it is under the agreement is there, it is under the village, and then how can the district council just bypass those things? And we have asked for resurvey also. The resurvey also was not done also, man.
You prove your bona fide first. I will see.
It was not disputed that it is our land, my lord. It is not disputed because why the respondent number, the third mandatory is respondent number. The respondent number 7 also fully admit, my lord.
Who is respondent 7?
Maybe appear.
Third village.
Because third mandatory and Namdang, they are in the same
side.
Same side only. That is not disputed. Regarding the land, there is no dispute, my lord. The dispute is that how can you, when you purchase that much land and you keeping land holding certificate beyond that land, and when we ask for survey by the officer of the district council, that was not done, my lord. So in view of that, my lord, it is there is no dispute regarding that. It is fully under the writ court, my lord, because it is quite done illegally, my lord. Because I'll go, my lord, to page 64, para 64 of the petition, my lord. Page 64 of the petition, my lord. Page 64, madam. Page 64, my lord, is regarding them. My petition, before the district council, my lord.
Page
64.
64
in this transition 65, my lord.
Huh? 64 is the annexure 12.
Yes, annexure.
This is a notice, I believe.
With regard to the subject mentioned above, I am to inform you that after proper with regard to cancel the pata to convert it to the landholding certificate. Because this
is for cancellation of pata.
Yes, my lord. I have prayed for cancellation of pata because let's go through, my lord. What is my application? The application of this of Romero Sunga, his respondent number 4, my lord. Respondent number 4. That with regard to the subject mentioned above, I am to inform you that after proper scrutiny and examination of your application, permission is hereby granted to cancel the pata number 2418 and at the same time, opportunity is given to you to apply a landholder certificate for the land. The area of the pata is 4548 square meter, my lord. It is very clear on record, my lord. This is the area which the respondent number 4, the owner has admitted. Hence, the pata number 2418 illegal stand cancelled by the office.
So what does this say? You're referring to a communication to the respondent 4.
Yes, because he is
saying that his pata has been cancelled.
Yes, because this is the root of everything, my lord. This is the root, because this is his pata is area is 4548. That's why I say it is admitted fact that it is 4548, whereas his the respondent number 5, he make it 4 pata. Page 91 onward, my lord. If you go to page 91, my lord.
Yes. Where's the clear copy of this?
Next, page 93 is very clear, my lord.
Page 93.
And here, my lord, it's quite different the way this council keep, my lord.
Yes.
Certified that according to customary right of landholding and by virtue so and so, presently residing and scheduled to clear so and so, then the land is liable to assess so and so, my lord. Then the map also is then here my lord has issue. The table clearly show, my lord.
Yes.
In page 93 and 97, my lord.
93. The area here is 93,000.
Yes, that's why he
square meter.
Yes.
Where's the correlation of this 93,053 with the one that you have referred to in page?
Because
65.
that is through that this is made, my lord. That's why the illegality is on the face of the record very clear. It is impossible.
Let us just compare 93 and 65. Here in 65, no boundaries are mentioned.
Yes.
Only the area. Area of the pata is 44548 square meters.
Yes, my lord.
There is a typographical error, my lord, in this patta. It should have been 45.48 acres, my lord. That has been converted to square meter, my lord. That is why in 93 the area has increased. It should have been acre, my lord. 45.48 acres, my lord. That has been converted to 93, my lord, in page number 93 as square meter, my lord. This is a typographical error here.
That's highly illegal, my lord. And not only that, the sale deed also, what they wrote, 4548.
That is the only typographical error, my lord, that we have stated in our affidavit. We'll argue our case, my lord. Now, first and foremost, my lord, whether it is the case is maintainable, and if the case is maintainable, it is appealable, my lord.
Let him finish. Yes, Mr. Kanji, anything else?
So your lordship can have clearly seen also that there is a highly illegality. So unless the merit has to be considered It is highly maintainable, my lord.
We will continue this hearing on the next date. Heard Mr. K. Sanjay, Lawyer, Senior Counsel, appearing for the petitioner. The hearing will continue on the next date fix.
It will come up on Monday, my lord.
Monday.
Or Tuesday, my lord. Since Monday, two other matters are Tuesday, my lord. Because I am suffering, my lord. My lord, either side, my lord, we are suffering, my lord. They are not allowing me to cultivate my land. I am at present the landholder.
You are Romario?
Yes, I am Romario, my lord.
Yes, Romario.
No, my client is Romario, my lord.
I know. You are referring to
yes.
the petition. Yes, you should be playing football then. Playing with politics. Let's expire on 19th. We'll have it on 19th.
19th, Friday.
19th is Monday. Mr. Kanjing? That's the calendar.
Yes.
19th.
Monday in one. It's okay, Your
Lordship. Your Lordship, this morning there was some confusion with regarding that in this case which we filed that was supposed to be before Your Lordship because the roster is before Your Lordship. If this matter may come up tomorrow, Your Lordship, that must there was
I'm
some
sorry, but tomorrow I'll not be in station.
Maybe
in fact, the
Your
whole
Lordship.
week I'll not be in station.
Maybe Your Lordship today, Your Lordship, because there's some urgency is there, Your Lordship. Movement order has also been issued. Your Lordship may take up now, Your Lordship.
Is the matter has the file been
I've already informed
that it should be a matter?
Your Lordship, just for interim protection, Your Lordship, because the matter is coming up on the 14th before Your Lordship. If some interim protection may be given to me.
What is the basis?
Your Lordship, I'm apprehending arrest, Your Lordship. I may be arrested at any point of time. I'm only praying for some interim protection, Your Lordship.
But who is there? Mr. Khan is supposed to be.
State, Your Lordship, state.
Mr. Sheikh, you are also state.
Yes.
Is Mr. Khan here?
Yes.
Then in that case, see, if there is urgency, then you mention it to the registry, and the matter will be posted tomorrow for any available bench.
Lordship.
Perhaps as a.
But Your Lordship, the entire record is before Your Lordship.
Well, that is for the registry to decide. Once the matter is placed before a particular bench, then the records will be produced before the bench.
Lordship.
I think you do that. Just approach the registry, and they can do it. If they may have to get an endorsement from the Chief Justice, or as a special case.
Okay.
Since the court will not be in station tomorrow. in any case, you usually see whenever a notification is issued, if any court is not available, that any urgent matter which is supposed to be taken up by that court will be taken up by such and such court. That's usually done.
Your Lordship.
You do that.